So let's continue on and spend a little bit of time talking about the first limb. In order for this to make sense of this, the rule only applies if the contract is wholly in writing. So that begs that first question, how do you know whether a contract is wholly in writing or not? I said before that one of my favourite clauses will be a clause that says, this contract is wholly in writing, because I want to reduce the opportunity for further dispute and further discussion down the track. So that's a good way. Look at the document and see whether or not there is an entire agreement clause. That would be what you often see it under that heading, entire agreement clause, or no extrinsic evidence, range of different things. So this is a fairly standard example.
What about if there is some more discussion before they sign?
And then they sign?
Yeah.
And they don't include those additional discussions in the document? Then, again, if it looks on the face of it that it is an entire agreement and a clause like this would suggest that it is, evidence of those discussions wouldn't be admissible. So these are really standard. The one I've got on the slide here is a really standard type clause. This agreement constitutes the entire agreement between the parties and supersedes all communications, negotiations, blah, blah, blah. Note the way that this is written, just as some practitioner tips here. See the use of capital A agreement there as a noun. Often in legal documents, legal contracts will be written with a set of definitions. This is something you might want to do in a memo yourself as well. If you're using the same term over and over again, creating a defined term, so talking about the agreement or the heads of agreement or the letter of intent or whatever it is, you might put after it bracket LOI and continue to use it, LOI or MOU or whatever it is you want to use. Use the same term over and over again. Sometimes useful in shrinking your word limits. You don't want to use so many words, but it also gets you into the discipline of using the same term to mean the same thing all the time. So notice here, this is actually been cut and pasted from an actual document. The term agreement is being used as a proper noun the whole way through, as capital A agreement, just as because it's talking about this document or this particular agreement. But in that sentence, the verb agreement is also used. Capital P parties is being used in the same way. So basically the court has two approaches, and there isn't a conclusive ruling to how to deal with this. There is a strict approach. So the approach that if a written document appears on its face to be a complete record of the party's contract, then all bets are off, no extrinsic evidence. The broader approach allows a court to focus on ascertaining the presumed intentions of the parties by admitting that extrinsic evidence. So in the scenario that Chef gave me before, I mean, I went straight to the strict approach, and I think if you signed without doing anything else, I think that's what the courts would do anyway. But the courts might take evidence of what the discussion was and then come to the view, well, it actually doesn't matter what that discussion was. If it had really been important to you, you wouldn't have signed that agreement, you would have buried it in some way. So we're not going to listen to that evidence. But if there was some other piece, some factual piece that wasn't in your scenario, everybody had their hands chopped off and it was only a flesh wound or some reason why people couldn't actually bury the agreement at the time, or a promise was made, or some fraud was.
What about time? Time was a factor.
Yeah, well, like the Van den Eschen example, maybe. Maybe it's like sign it now, but I'm promising you, and that would be probably that's the evidence of a collateral contract. It's like I just sign it like this right now, and I promise you that I won't enforce X unless Y happens or something like that. Maybe, but we'll talk about how the collateral contracts work as well. I would never advise anybody to allow their clients to do that. It'd be a very, very risky play indeed. So what does the strict approach mean? If a written document appears on its face to be the complete record of the party's contract, then extrinsic evidence will not be admissible to add to, vary or contradict. This means that you will not be able to bring that additional evidence. The court will only look at the agreement, so the written agreement, unless there's something in the terms themselves that indicate that maybe the written agreement wasn't intended to be the only record. So, for example, if you had an agreement in the form of a letter and the letter referred to our conversations about the sale of the property last week, or in accordance, in accordance with our conversations, you'll do the cleaning to X standard, that would indicate to the court that the document itself was not all of the information, that there might be some other information that's relevant to understanding what the terms were. Sorry, I've got an example in my head that I haven't articulated particularly clearly. Was that confusing you, or Zoe, you were looking a little bit like it was, what is she talking about? But, so the more relaxed or the broader approach only applies to written agreements that the parties themselves intended should be the sole and complete record of their agreement. And you can determine whether or not this is what the parties determined. In order to do that, you can admit evidence of surrounding circumstances and negotiations. So if you try and work out what the parties intended objectively, then you have to look at what was said, whether that's in the written agreement or whether that's in the other conversations. Now, this is particularly unhelpful at the moment because Australian courts are taking both approaches, particularly at the lower court levels. They'll be more likely to take a stricter approach for expedience as much as anything else.
Does it also depend on maybe, for instance, the power of the contract? So as to who...
To a power imbalance?
Yeah.
Yeah, actually that's a good way of thinking about it. Yeah, I think it possibly would. The more likely it is that the parties have negotiated, I think the more likely a court is to consider that if their power balance is relatively equal, that everything that should be in the contract will be in the contract at the end of the day. Where if you've got one commercially very strong party and the other party with less bargaining power, particularly if one party is legally represented and another isn't, they're probably more likely to take evidence of the larger set of circumstances, looking for the fairness quotient. But look, that's just me thinking about cases like Amadio, and even cases like the shipping company cases that we've just looked at, and thinking when there is that imbalance, I'm seeing that more. Yeah, it's really good point. Nice critical analysis point there for you. We learn legal rules by studying the exceptions to them, and the parole evidence rule is absolutely no exception to this. And there are key exceptions that apply, and we're going to look at 3 of them. We're going to look at being able to get around the rule by essentially proving or being able to demonstrate that the rule doesn't apply, because the rule only applies if the whole of the contract is in writing. So by demonstrating that the intention of the parties was that their contract would be partly in writing and partly verbal is essentially getting around the rule, because then you need to bring in the verbal elements. Being able to prove that the representation gave rise to a collateral contract, which I started to talk about before, or demonstrating an estoppel. So being able to demonstrate or proving an estoppel, in other words, demonstrating that notwithstanding that the rule is there and that a party would in normal circumstance have the right to prevent evidence from coming in, that something in their conduct or behaviour or the promises that they make limit their right in equity or remove their right in equity to exercise that right. So let's deal with the easy one first. The rule only applies for contracts that are fully in writing. So if you are in a position to demonstrate that your contract was partly oral and partly in writing, then the rule doesn't apply. So in Equuscorp, I'm assuming that's how you say it, the court held that a subsequent written contract superseded a prior oral agreement. So in this case, there was some parties had invested in a prawn farm or some sort of aquaculture investment. It had gone badly. They'd had some negotiations. They'd come up with a plan for what they were going to do, and then subsequently they agreed something else and they put it in writing and signed off on that. And then the investors were still unhappy and sought to enforce their earlier written agreement. So we use this case to explain, and this one is in your, I think it's in your casebook. Yeah, I'm sure it's in your casebook. And it's used here to illustrate this idea that there is a difference between an agreement that is fully in writing, an agreement that is partly in writing and partly oral, an agreement that is entirely oral that is subsequently replaced by another agreement, which in this particular case happened to be in writing. So in this case, the court ultimately found that this fell into those third of those categories. They said you had an agreement in writing, you then agreed to replace that agreement with a written agreement, and you can't go back. Newer agreement trumps older agreement. Agreement in writing trumps the agreement that you had, if in fact you made it in verbally. So the significance of this case is that the High Court of Australia seemed to accept that extrinsic evidence can't be simply rigidly excluded, but they still came out very much in favour of upholding the written contracts according to their terms. So again, writing is most likely going to trump people's memory of what happened verbally. Now, the one that I'm actually hoping that we'll end on today, probably a couple more actually, we'll keep going for the next 15 minutes or so, is this idea of the collateral contract, which can be quite hard to get your head around, and then suddenly it'll hit you like legal logic and you'll never think the same way again, so I'm sorry. But this idea of a collateral contract is the extent to which a promise is made in addition to, but independently of, the underlying contract. So we have two contracts. The contract that might be the subject matter of the dispute, and another contract that's been made often in order to induce somebody to go into the first contract. So a collateral contract involves a promise, not just a mere representation. It needs to be made to induce somebody to enter into the contract, but it can't be inconsistent with the primary contract. So let me give you an example. We'll use the case of Hoyt and Spencer here. So Hoyt, this is back in 1919. Hoyt did then what they do now. They operated cinemas. And Spencer entered into a lease with Hoyt's to sublease some premises where they were the head lessee of some premises. And there was a clause in the lease agreement that said that Hoyt's could terminate Spencer's lease on 4 weeks' notice. It was a 4-year lease, but at 4 weeks' notice they could kick him out. It's the other way around. Spencer was the landlord, Hoyt's was the tenant. So Hoyt say to Spencer, what's that about? We can't just take our projection screens and our seats and leave on 4 weeks' notice. We wouldn't be happy with that at all. And Spencer says, oh, don't worry about that clause at all. I'm only going to exercise that right if the head lessor asks me to. So Hoyt thinks, okay, that's fair enough. Signs the lease. Later on, Spencer says, 4 weeks notice, mate, you're out. Not because the head lessor had asked him to, just because they got sick of having them as a tenant. So the question for Hoyt's was, is there a collateral contract here? Now, under the parole evidence rule, Hoyt's doesn't have a clause in the contract that says you're not going to exercise this term. Hoyt's has a contract, and the contract says we can give you 4 weeks notice. So there's no breach or anything. So Hoyt argues here that there's a collateral contract, that there is a second contract between Hoyt and Spencer where there was a promise that was made that you would only exercise this particular term in a particular way. Consideration was given for that promise in the sense of entering into the main lease. And so we have this idea of the collateral contract. So do you see what a collateral contract is based on that argument? Unfortunately, it didn't work for Hoyt's in this circumstance because, as you remember from earlier, there are 3 requirements. And the last of those requirements was that the terms of the collateral contract need to be consistent with the underlying contract. And it would be completely inconsistent to have this term that is patently completely different from the key term in the agreement. So the words from the case here are, the truth is that a collateral contract, which may be antecedent or contemporaneous, so it can happen afterwards or it can happen at the same time, being supplementary only to the main contract, cannot impinge on it or alter its provisions or the rights created by it. Consequently, where the main contract is relied on as consideration in whole or in part for the promise contained in the collateral contract, it is wholly inconsistent. It is a wholly inconsistent contention that the other party is not to have the full benefit of the main contract. Okay, so we use this to illustrate what a collateral contract is, or that's what the textbook is using it to illustrate that point. But it's kind of not helpful because they didn't find a collateral contract in this particular circumstance. So I'm going to talk to you about another case. Actually, sorry, I've got some points here about Hoyt and Spencer, but I'm going to move on. I want to talk about another case here, which is, sorry, I moved these around earlier today. It's not in there. All right, I'll just put that slide up while I'm doing it. There's another case that I usually talk about in this circumstance, which is Shanklin Pier and Dettel, which I think is a better example of the use of a collateral contract. It's not in your casebook and it's a little bit difficult to find, so I'm just going to tell you the story of it and hopefully relying on my memory to get it right. It's an English case. Somebody might need to Google it for me to give me the years. I want to say mid-60s, but I'm not exactly right. I'm not exactly sure. But the point of this case is this. So Shanklin Pier, no giveaway from its name, owned a pier. And they decided that they needed to get their pier painted. And Dettel Paints sold paints. And Dettel's paints were particularly formulated for use in wet areas. So you can imagine piers, they're pretty hard to keep painted. They have a lot of weather elements. There's a lot of things that you need to think about. And Dettel went to them and said, we've got some really great paint. It's absolutely perfect for what you need. And so Shanklin Pier then put out to tender the job of painting its pier and specified Dettel paints. So, I don't know, Fred Blogg's painting company won the tender, and under the terms of the tender they got paid to paint the pier, and in order to comply with the terms of the contract they had with Shanklin Pier, they had to go off and buy Dettel paints to paint the pier. Well, it turned out that the paints were wholly unsuitable for the purpose, and within a very short period of time they stopped working. You know, it's peeling, it's rotting, there are barnacles, I don't know, whatever kind of painted pier problems. It's like an alliteration nightmare. Whatever kind of painted pier problems they could have, they perfected those painted pier problems. And so, for whatever reason, they didn't involve the painting company in this. But what they did do was sue Dettel Paints. And Dettel is saying, well, you don't have a contract with me. So, I know where this comes out. It comes out in privity. That's where the slides are. And this is why I want to note it. So, be in some of that other stuff that I've given you. But we can look at that as a collateral contract. That essentially there was a contract between, the only way that Dettel got to sell its paint to Peter Piper Painting Partnership was because it was specified in the main contract. And so it was consistent with the main contract that the paint should be suitable for the purpose of painting piers. Hopefully that's a good example. Let me go back though and make sure that we cover off on these points. So, Justice Isaac, the promise in the alleged collateral contract impairs the contractual rights of Spencer to the main contract. But for the additional promise alleged in the collateral contract, Spencer had the power to do exactly what he did. So it makes no sense to find a collateral contract that is inconsistent with the right to exercise that power under the key contract. But from the point of view of thinking about this from the parole evidence rule, evidence of the negotiations was admitted, discussed, but ultimately unhelpful because it was inconsistent to the extent that there was potentially a collateral contract, was inconsistent. So if they'd been able to bring it in some other way, they might have had a different result. What else do I want to talk about here? Let's talk quickly about the second limb. The other key reason that you might want to bring in parole evidence is to explain what a term means. So you'll remember the quote that I read to you earlier from Kirby kept referring to the contract itself or the document itself being enough if the terms are unambiguous. Opening up that opportunity for extrinsic evidence if there is ambiguity. And Justice Mason and Justice Wilberforce made it very clear that if there is ambiguity, additional evidence is available. So the rule itself limits evidence being given by parties to explain the meaning of the terms.
Sorry, Kat. I'm still perplexed. Point Spencer.
Yep.
Collateral contract.
You can bring in evidence. The point here is you can bring in evidence to demonstrate a collateral contract.
Yep.
What's really annoying about that case is they didn't find a collateral contract because the requirements weren't met. Does that help? Sorry, I feel like I've gone a very long way around to get here because my key point is about the evidence rule, but I want you to understand what a collateral contract is.
Yeah. I'm modelling. Probably right.
As you frame your question, feel free to come back to me.
Yep.
Okay, so we're back on the second rule, second limb. So the scope of evidence surrounding circumstances to the written contract is admissible to assist in the interpretation of the contract. So if the contract uses a particular terminology, refers to particular standards, refers to time periods, refers to what's important or what's not important, bringing in evidence of what was going on might be necessary in order to put the court in the position of that reasonable bystander. Because the reasonableness test generally requires this fictional reasonable person to be in the same position, have the same knowledge of the parties. So you need evidence of what that knowledge, what that situation, what those circumstances were. So Codelfa is the key case here. Codelfa is a case that you will find comes backwards and forwards all over the place. It's basically, I don't know I think about it when I'm catching the bus on the weekend to come into uni for something or other, and because they're building the crossings. So basically, Codelfa was a contractor to the State Rail Authority. They were building, I assume, the New South Wales version of the rail crossing project. I can't remember what they were building, but it was a major infrastructure project. They said they'd have it done by a particular time. Time is of the essence in this contract. So there's a specific term that says it's an essential term. Getting things done by a particular time is essential to performance of this contract. But it turned out when they actually started working, they were very noisy, there were lots of interruptions. Local councils came in and limited the hours that they could work. So they weren't able to work overnight, which is what they originally planned to do. As a consequence of that, their time got pushed out. It just wasn't possible to do things in the time that they said they would do it in. And so the state government sued them, essentially for not delivering on time. And they sought to bring in evidence of the surrounding circumstances, including the circumstances of the negotiation, so that they could explain to the court what that term meant, and presumably levy an argument that whilst there was a time period in which to do it, what was important was that they did it as quickly as they possibly could, and that the term should take into account the limitations that arose subsequently as they had different hours that they could work or not work. So Justice Mason ultimately said the true rule is that evidence of surrounding circumstances is admissible to assist in the interpretation of the contract if the language is ambiguous or susceptible to more than one meaning. But here they used a narrow approach. So the words in the contract should be given their plain and ordinary meaning, and the recourse to evidence of the surrounding circumstances was only necessary if there was ambiguity. And in this particular case, they said there is no ambiguity. You have to get it done by that date, and if you don't get it done by that date, you're in breach. Now the key case here is Royal Botanic Gardens and Domain Trust and South Sydney City Council. Here we've pretty much got, we've got Chief Justice Gleeson and Justices Gordon, McHugh, Gummo and Hayne talking about evidence of surrounding circumstances being admissible to assist in the interpretation of a written contract if the language is susceptible to more than one meaning. So in this particular case, they were looking at a phrase that talked about the trustees having regard to additional costs and expenses, and they were trying to understand what those additional costs and expenses, what might have been contemplated by that. And in that particular case, they found that there was ambiguity as to which of the alternatives was intended. So was it additional costs, additional expenses? How are expenses different from costs? Again, each of them turns on the phrases. So I think I'm going to finish there because my slide pack is doing weird things and we're pretty much at 8:15. Questions, concerns, thoughts? So we'll continue on with applied terms next week.